As most of you already know, this is live, but it will be posted and available, and you will have access to it along with past virtual meetings on our website, provided you're an AASEW member. You may watch this video over and over again as much as you want, and you can also watch previous videos. And if you remember it or not, we've already had Mediate Milwaukee, but it seems to be especially important in this day and age where you do not have the ability to take people to court without very closely dotting the I's and crossing the T's. If you want to watch this video again, or any other ones in the past, just go to AASEW.org and you can access any of them. And again, as a reminder, we have an earlier video explaining Mediate Milwaukee, some of the services they offer, probably in more detail, perhaps may go into tonight. It'll talk about some of their connections with resources available for both landlords and tenants. We will also send this video out to you as well as all our current members, so you'll be getting it tomorrow sometime. Up until recently, the only tool we had available as landlords to deal with non-paying or uncooperative tenants was to take them to court or file an eviction. We now have another tool available to us, Mediate Milwaukee. Well, it's not a silver bullet. It's a valuable tool for us to use, especially with what we have going on now. Mediate Milwaukee is part of the RHRC, that's Housing Resource Center. If you want more information, RHRC, go to our video library, and we actually have a video on that. Amy, excuse me, I'm a first name kind of person, are both professors at Marquette, and they're on the Marquette faculty. And I'm going to turn over to Tim, and he's going to explain some of the benefits that he has found using their systems for his rental business. Tim?
Good evening, everyone. So I was unaware of mediation, or at least pre-eviction filing mediation, and just slightly aware that you could enter into mediation as part of a eviction case. And when we were working with the Rental Housing Coalition, and also when I had one of my staff people looking for resources that we could provide tenants, Mediate came up a couple times. And so towards the end of the Wisconsin eviction moratorium, I placed 2 tenants that we had that owed us 3 or more months rent with Mediate Milwaukee. And the results I received were very similar, or the agreement we made was very similar to what a stipulated dismissal would have been had we gone through the court process. But there was also the advantage that Mediate was able to walk the tenants through the application process to get some of the different grants that are out there. And both of those tenants remain tenants with us today. And that would not have happened without Mediate. And so we were able to collect rent and allow the tenant to stay in possession of the unit. So that was a benefit to everyone. And we implemented a policy at Affordable Rentals that before we take any tenant to court now for non-payment, we are placing them with mediation. If you enter into mediation early in the process, you don't really have much of a disadvantage. There's not much of a time disadvantage, and there's a lot of advantages. And there's advantages to the tenants to participate as well, because they can get through it without an eviction on their record. As landlords, we benefit because we don't have the cost of eviction. And Mediate helps the tenants navigate the funding options for various grants and programs that can help them pay their rent. And you know, one really surprising benefit was there was a real reduction in conflict with many of these tenants. As we entered into Mediate, my staff was telling me how some tenants that were quite hard to work with became more polite, which was a good benefit. Today, now that we're facing the CDC declaration, there's even more motivation, I think, for an owner to look at mediation as an alternative to eviction. So that's the policy for affordable rentals that, and we plan on continuing this policy well beyond COVID and moratoriums. And hopefully well beyond COVID comes pretty soon, because I think we're all getting tired of this. So that's my take on Mediate Milwaukee.
Well, thank you, Tim, very much. We appreciate this opportunity, obviously, to speak to all of you. I'm going to go ahead and pull up a PowerPoint, and then I'll turn to you, Joanne. Okay.
So hi, everybody. Again, as Amy said, thanks to Tim and Ron for inviting us back to kind of provide a little bit of an update to some of the things that we've seen going on. Some of the, if those of you who were with us in May, some of these things will be familiar, and then we've provided some additional updates of information. Thanks, Amy. So first of all, part of the reason that we are involved in this process is to help deal with conflict, right? It's inevitable, it's normal, and most of us don't like it. And for whatever it's worth, it's not like Amy and I dive headlong into conflict. We do this as part of our work, but we try and help to make conflict more manageable. And a lot of people intentionally avoid disagreement or confrontation because it makes us uncomfortable. So doing that obviously doesn't help. It doesn't move the process forward, and you can't get there through conflict avoidance. So the sooner we can get people to engage, the better. And kind of to what Tim just said, we're seeing some positive results through engaging with people sooner than later, and for a couple of reasons. The temperature isn't as high as it would be when things have gone further. And as well, there's more ability to come up with workable, possible solutions when someone isn't in such an incredibly deep hole. Now, COVID has added a whole nother layer of complication to it, but that's just one of the things to think about, is the nature of conflict and what it brings to us. Amy, you want to go to the next slide?
Yep.
So mediation is a way to, our goal is for it to be a way to constructively engage with conflict. And not everybody wants to do it. That's one of the initial challenges, is that there will be parties that will not be interested in doing this. And that's okay. It is a voluntary process. It's a confidential process, which allows people to, that confidentiality will often give people more comfort in terms of the communication piece. So what does that confidentiality mean? It means a couple of things. First of all, it means we can't ever be brought into a subsequent legal conflict and asked to speak to anything that was discussed in the process. We also have the ability to add another layer of confidentiality within the process, where either of the parties that we're engaged with in mediation can ask us to keep information just between the two of us. So if Amy's the tenant in the dispute, and Tim's the landlord in the dispute, and Tim says, you know, there's something I want to share, but I only want to share it with you because I just want, you know, your thoughts about something and how you think I might approach this, but I don't want you to discuss it with the tenant, then I will respect that request for an added layer of confidentiality. Absent that request, Amy and I both will share information with the parties that in a way that we try and advance forward momentum. So We may reframe something that someone says because they're upset to say, well, I hear this in terms of the tenant's perspective, or I hear this from the landlord's perspective. But again, there is this ability to keep this added layer of confidentiality, which can be helpful to people. It gives them the ability to really just let go sometimes and express information that they're very frustrated about. So it puts us in the role of being a neutral, a third party, which can really change the dynamic between people. I had specifically an experience where a tenant that was very upset at the end just said, it just feels so much better to just get that off my chest. Great. That's part of our job, is to just be there to let that happen so that the parties can then engage more productively. It's not our job to judge. It's not our job to decide. And it's not our job to judge based on even the facts of the particular situation as it's presented to us. Some of these situations are very difficult. We share the information as effectively as we can. But our role is just to try, again, to advance this process towards an outcome that's more productive and more beneficial to both parties. So that might mean a pay and stay agreement. That might mean an agreement to move. And sometimes that's the starting point, is to talk about, what do you want here? What's going on? And it might be that the relationship is sufficiently damaged that the parties say, it's best for us just to move on. Great, we can use that as a focus and go. And it may be, no, we'd like to stay put. It just depends on what are in the interests of the various parties. So our job is really to focus on the process, and the party's job is to focus on the outcome. And although we have a strong preference that people can reach a mediated agreement, we don't have a preference as to what kind of mediated outcome they come to. We would love to see the situation be resolved through mediation if possible, but what that actually looks like is really dependent on the parties. Okay, next slide. We provided this information about the confidentiality piece because we get questions about that. We are statutorily not allowed to provide information, as you can see under the Section A, the inadmissibility piece, in any sort of judicial or administrative proceeding. So that's a very specific protection. And it's drafted that way with the very direct intent of facilitating open communication during that process. And then one of the exceptions is it doesn't apply to a written agreement or stipulation or settlement. So if you reach an agreement and somebody breaches, that document can be brought in if you end up filing a subsequent eviction as a demonstration that you had done a mediated stipulation, the stipulation failed, and here's what you had tried to accomplish. Amy?
Okay, so touching on the services that we offer, oftentimes when someone applies for mediation, it may be a situation where the other party is unreachable or the other party doesn't agree to engage in the mediation process. So we consider that an opportunity to consult with the party who requested mediation and be able to provide them information about resources that may be helpful to them, or just general coaching, as we call it, in terms of how to move forward outside of mediation. We don't give legal advice, despite the fact that we are attorneys, but certainly we can give some suggestions on how to deal with the conflict, or again, resources and options for moving forward outside of mediation if that doesn't happen to be an option in the circumstances. When both parties agree to engage in mediation, our most common format is shuttle telephone mediation. So we're talking separately with the landlord, we're talking separately with the tenant, and really sharing information in between the parties, which we find takes a lot of, as Joanne described, we can listen to the frustration and the venting and acknowledge what that individual is going through, and take the substance and the essence of what they're looking for in a neutral and non-emotional fashion to the other party. And we found that's really the most effective way for us to work through this process. Sometimes we do handle a three-way teleconference mediation, but that's really at the request of a party or both parties, or in a situation where we find it would be helpful to speak jointly. But I'm sure you can imagine it becomes more challenging as a mediator to manage that discussion with two people on the phone if the emotions get high. We have go ahead.
And it's also logistically more challenging because people's schedules don't always
Yes.
line up, and so that's another challenge.
Exactly. Historically, we did face-to-face mediation on the return date in court. And from time to time, prior to a court hearing, we would have in-person mediations where we would go into the community and use library or other space that was available to us. Obviously, with COVID, we've suspended those activities at this point. So again, if you're engaging in mediation with us, it would most likely be the shuttle telephone mediation. Certainly our goal in the mediation process is to work with both parties to help identify a process or solution that is agreeable to both parties. So it never would be a circumstance where we are forcing parties into an agreement that doesn't make sense to one or the other. As Joanne pointed out, it is a voluntary process, and entering into a mediated agreement is voluntary on both sides. So, and we, again, don't have a stake in the outcome beyond we want people to have a fair process to try to work through and see if a solution is possible. Some of the solutions we've helped parties reach is an agreeable move-out date, something related to payment plan is usually involved, and now we do have access to help tenants apply for COVID-related rent assistance through our partnership with community advocates. So that is often becoming part of our mediated agreements. Sometimes if that amount doesn't cover the entire arrearage, we're able to also incorporate a repayment plan. We've had other cases where the agreement involved COVID-related rent assistance and a move-out date, where the landlord was willing to give some more time to move out once they had those funds in hand. And really, we can incorporate any other terms that the parties are going to find agreeable. So if it's a court-related mediation where we're drawing up a stipulated agreement for court, those issues will only relate to repayment plan or move-out date, but we then add a subsequent document, the mediated agreement, that could incorporate some additional terms. If it's outside of court, then that agreement would simply be the mediated agreement between the parties. Just to highlight for you, in terms of the COVID-related rent assistance, that is being administered through SDC, the statewide RAP funding, and then Community Advocates has some city and county-based rent assistance through the CARES Act, as well as Hope House. So we do have a point of contact at all of these organizations. We have some ability to check on the status of rent assistance applications at SDC and Hope House, although we haven't had consistent success in being able to do that. But we do have consistent communication and success with community advocates and being able to shepherd an application through that process start to finish in a pretty efficient time. So when people come to mediation and haven't applied for rent assistance, that's where we're gonna direct individuals and work through that process with them. And we're gonna continue to try to develop the process so it's similar with SDC and Hope House. It's just a matter of, I think, capacity at all these entities to be able to add systems to allow for efficiency between the partnerships.
So kind of on a global basis, what are some of the benefits of mediation in a landlord-tenant situation? One is it gets the parties to the virtual table, right? Right now, we're not talking about doing anything in person, but it gets people to engage and hopefully in a way that can be more productive. There's the piece of privacy. The sessions are confidential, so people can, to Amy's earlier point, and I think mine as well, sometimes there's a lot of emotion on both sides, landlord side, tenant side, right? These situations can be very frustrating. There may be histories that are challenging. There may be other people that are involved. So it gives people an ability to have some space to just talk and say what they need to say. The parties have a lot of this idea of self-determination, right? The outcome, the solution is really up to the parties. And the mediator's role is to help facilitate that. And, it does require some give and take on both parties, right? Somebody might say, I don't really want to move out. Well, your landlord really does want you to move out. And so would you like to move out on with you controlling how it happens, or would you like to have it happen with the control of the court, right? So it's that idea of helping people to see where is there a better solution. So that's, the idea. People have communicated to us that they were surprised that we would mediate a move out, that it seemed counterintuitive. But a move out without an eviction being filed is a far better outcome for a tenant than a move out with an eviction being filed. So this idea of controlling the solution is certainly very helpful. You maintain your legal rights, so you don't give up the ability to take alternate steps if there is no agreement, right? So we can go through this mediated process, and if it doesn't work and you don't get to a resolution, then you take other action. And at the same time, if there is an agreement and then there's a breach of the agreement, you still haven't given up any rights. I can speak to affordable rentals because I do a lot of the mediation related to their cases. And one of the things that they have done is when there are mediated agreements in place, as Tim said, they're waiving fees, late fees, and any other kinds of fees that would typically be charged. And even if there's a breach in compliance, they call back to Mediate Milwaukee and we'll re-engage. So I may contact a tenant and say, hey, what's going on? Tell me where you are, what's happening, what's the challenge, and we'll figure out, is there a way to resolve this? So again, we've seen some situations where it does go back and forth, and we've stabilized agreements that have been, that have gotten a little bit bumpy. Another benefit is there's a written agreement. It's made in good faith. It can be shared. In the case of Tim's, they incorporated into the record with the tenant, so they can see what that particular agreement was, and have a reference, and they can say, okay, this is when payments should be made, and they can monitor it within their own system. Same thing when we do them with the court, right? We file, if we have a court-connected mediation, we will take care of drafting that agreement, as Amy has noted, and getting the STIPs put up into the court, and then that information is there. And again, if you had an agreement that fell apart, that was an agreement made in good faith, that agreement can be shared if you have to end up going to later deal with it through a legal remedy. And the last piece is probably one of the most important pieces, which is it's an opportunity to reset expectations and to hopefully reestablish or improve communications. Oftentimes, these situations are worsened by misaligned expectations. COVID has created an extraordinary set of additional circumstances. So if you take COVID out of it, prior to the COVID pieces, sometimes it's about gaps in expectations. And so we also talk, when we resolve situations with a mediated agreement, we'll talk with the parties about, okay, can we talk about forward-going communication? What is it what's the best way to communicate with one another? If there's going to be an issue with something, how do you want to handle it? So we talk about trying to anticipate that communication isn't going to be perfect, and landlord and tenant relationships can be difficult sometimes. And so we try and anticipate, okay, what might happen in the future, and what are we going to do when there is a challenge, as opposed to waiting until it presents itself and we haven't had that conversation. So this notion of resetting expectations and improving communication is really helpful. Amy?
Some other benefits are mediation process is available at no cost to the parties. If you engage in mediation prior to the court filing, if we're able to get a mediated agreement, you could avoid those costs altogether. And time is money. We try to have an efficient process, particularly as related to or in relation to how the court process is going at this point with the delays. So we certainly encourage everyone who's interested to try mediation. We know it certainly isn't appropriate in every circumstance, and we're not trying to convince you by any means that it is. But if there are cases where you feel it might be worth trying to, for example, now with the CDC moratorium, try to work out an agreement with the tenant in the meantime. This is certainly a low risk, so to speak, way to try to do that, and it may give certainty to the next few months in terms of payments or if there's a possibility of a move out. I feel like we've touched on this, but certainly we are and have been for the past couple of years engaged with community organizations around trying to develop resources for tenants and landlords. And we've specifically partnered with a number of groups to develop the Rental Housing Resource Center, which Ron had mentioned at the outset. And I've mentioned we have a active partnership with community advocates right now to help facilitate applications through the process to get COVID-related rent assistance. And then we also do work closely with the small claims court to be able to file stipulated mediation agreements. So we're able to e-file those directly once there is an agreement through mediation on cases where there is an active filing in court. We've actually even had some cases where the writ was granted, but subsequently through helping the parties get rent assistance or other conversations, reached other solutions to be able to go in and file that stipulated agreement, vacate the judgment, and then work with the parties to move forward outside of court and outside of executing that writ. So that's all we have for our formal presentation. I think at this point we're going to move into some Q&A.
So I'm going to start. There's some in the chat page that I was reading while Amy was covering the last few items. Heiner asked if we've had any CDC. No, I have to see where they go. Heiner asked if we've had any CDC situations where a question arose whether a tenant could pay partial rent. Not really as in anything other than, I mean, I guess, Heiner, I'm looking for some clarification. Are you talking about in court or are you talking about pre-filing? Oh, well, okay.
Am I there?
Yeah, you're there. Hi, Heiner.
Okay, I'm in. Sorry. Well, either one, but specifically, I guess, the court filing. Interestingly, I recently had a case, first hearing, and the tenant during the return date stated that she hadn't paid since June, but she indicated that she's recently gotten approved for UC. So I want to get in touch with her on behalf of my client, and I'm thinking what I probably should do is refer her to you and have her talk to you as to what she possibly could pay, because she should pay something. She hasn't paid for a good number of months, and of course otherwise she won't be paying anything till January. So I was curious whether you had had any cases like that in the meantime.
Not specifically that I've had where somebody has said, hey, I think they could do a partial, where a landlord's been willing to try and has said specifically, I'd like you to try and negotiate some sort of a partial payment. I haven't had any experience with that, but not that we wouldn't be willing to do that. And one of the things we do try and do is to provide some clarification to people when they'll say, well, there is this ban. Yes, there is, and the ban doesn't mean that you don't have a responsibility to pay your rent. It certainly means that you can't be evicted right now for that. And we explain to people that not, kicking it down the can down the street isn't helpful, because come January, something's going to change. So we do try and make sure we educate people if they have misinformation about what the terms of those moratoriums mean, that sort of thing. So, if someone wants to try and do a partial agreement, we'd be happy to do that, Heiner. If there's, if that gets someone some stability and some headway on what's going to be a future obligation, and they want to stay in place, right? The likelihood is the best way to deal with that is as best as you can in the meantime. Amy, do you want to add anything?
No, but I think certainly that's a good example of during the moratorium how we can add some benefit that may not be available through other resources.
And the other thing that we do in mediation is we try and really ground truth, and the party, particularly the tenant, when they say, here, I'd like to, I can do this. We will actually reality test what people say to us based on their ability to pay, because people really want to try and say, oh, I'll do something. And we want to make sure that what they can do is feasible. So reality testing the commitment is an important consideration.
Great, thank you.
Amy, you want to take the next one?
Yeah, I see a question: who writes up the agreement, and is the agreement written immediately and signed? We as the mediators write up the agreement, and we either can meet with some parties if they don't have access to a way to sign electronically, to meet in person at our office to get that signature. Sometimes the landlord and tenant see each other with some frequency, and the landlord can help facilitate getting that signature. Other times we use a program called RSign that's very similar to DocuSign, where we can just email the document for a signature, and party can sign it on their smartphone using their finger, or just type in their name to create the electronic signature. But if it's a court-related mediation, we're then able to e-file that with the court if it involves a stipulated dismissal. Otherwise, we get copies to both parties, and they can rely on that moving forward.
There's a question about what if a payment plan is made and they don't abide to it in the full amount when due. I think I highlighted that a little bit as it really, when I was talking about some of the stuff with affordable. If it's a pre-filing piece, then it's really between the landlord and the tenant to talk about, okay, well, there's an issue here, what's going on? That might be where you would re-engage us if we were involved in helping to get to that mediated agreement, to say, there's been a default, what's going on? And often the parties will respond to us. Sometimes people, go missing. We deal with each of those as they come. And in some cases, it might be negotiating new terms. There's been maybe a change in circumstances, but we address those, one case at a time. The second part of that question was, how long does it take to get wrap funds? What if a tenant says they applied, yet the landlord hasn't been given any paperwork? I think a couple things that Amy and I can both share about this. There are 3 different groups in town, as we identified: SDC, Community Advocates, and Hope House, all who have some ability to provide some funding. We have a very well-established partnership with Community Advocates. Oftentimes what we've seen is that tenants will say to us, I've applied, and they've maybe sent an email and they're waiting to get an email reply. And they don't know if it was SDC, or if it was Community Advocates, or if it was Hope House. So one of our hopes with today is that all of you have information about what are the funding resources, what are the things that a tenant needs to do, right? Most of the groups have an application, some sort of a rental attestation, identification. Because it's COVID-related loss of income, they're going to have to provide some sort of verification from an employer. So all of that information is going to have to get into whatever entity it is in order for them to be considered for funding. And then it takes some time. And as Amy said, we have a very reliable ability to check the status of Community Advocates. We've had good success there. We have less reliable success with the other 2 groups. And so, the more that you can do to facilitate letting your tenants know, hey, there are these resources out there and here's how you access that. That's probably a good thing. I'm just looking at the list. There was one there where there was a tenant was taken to court for rent but was postponed to the CDC moratorium. Tenant is involved in illegal drug activity. I can't give legal advice on handling the latter, but there are a couple of attorneys I'm seeing online who might want to speak to that. But there are some clear exceptions to the CDC moratorium that speak about when you can nonetheless proceed with an eviction. And so it's important to know what those exceptions are and how to navigate those exceptions if it's going to take you into court again.
One thing I would add is that, so when we started working using mediation, we added language to our 5-day notices and rent reminders, encouraging tenants to reach out to Mediate Milwaukee and informing them about the community advocates and SDC programs. And we also put a link on our company webpage that has a bunch of resources for the tenants. I think that's helpful because as a landlord, you only succeed when your tenants are succeeding. And you know, if your tenants are failing, it's going to be costly to you and potentially could cause you to fail.
I see a question here. Will you help people who are served a 28-day notice or only those that are behind in rent? We'll work with anyone. There doesn't even have to be any notice served. It can be pre-notice, pre-filing, really the whole spectrum of the tenant-landlord relationship. We can be of assistance. What if both latent rent but seller just wants tenant out for showing, so served a 28-day notice? We would work with them as well. I mean, the options are smaller in those circumstances in terms of types of outcomes, but certainly we could have that conversation and see if we could help facilitate a move out date that worked for everyone.
Another resource, and perhaps community, I don't think community advocates would get upset at me for saying this, but if you reach out to them and ask for Debbie, or Sadie, maybe you can give her last name, she will do the same thing and she will look and see if the tenant has indeed applied to them. Because many times that's all you need to know, and then she can also tell you what else they need from that person. They've been very helpful, and if you go back and you listen to the community advocate video that we had approximately a month ago, Debbie was one of the people on there, and you can get that information on that.
Yeah, and we'll often start when we're dealing with a tenant that says, I have applied for assistance. I know I'll just send an email to our contact that says, can you search his name and tell me if this person is in the system? And if they're not, then if, you know, I will send to them the things that they need to put together for me to review to get to community advocates. And once community advocates has everything they need, then they're going to contact you as the landlords to have you verify some information. So once you've gotten that communication, you know things are moving. And then once they finalize it, it does move relatively quickly. But what we had seen in the beginning was that there were some snags, you know, as some of the bugs got worked out. We also saw that there are people that have applied for unemployment that have been waiting for months and months and months. So that's causing some added complication here. And we don't have any ability to get any information about anything in the unemployment system. I see that Evan is answering some of the legal questions, so thank you, Evan. And Sadie put Deb Hefner's information in there. Deb is the person that's coordinating all of the rental assistance staff and funding activities at Community Advocates.
I've got a couple questions that were sent to us pre-meeting that I think are worthwhile in addressing. So how do you deal with concerns about a bias, whether it's the landlord or the tenant thinking that you're working on behalf of the landlord or on behalf of the tenant?
Amy, do you want to take this or want me to take it? Okay, so one of the things that we have found is whoever calls us to request mediation, when we call the other party, that other party is invariably more defensive and feels like we are already, you know, favoring the party who called us. So part of our job is to help kind of deal with that piece and explain our role. You know, it's human nature to, there's always going to be things where you feel like, wait, if you ask me a question about something at my property, are you not supporting me? And that's not it at all. We have to ask questions of both of the parties, sometimes things that are difficult or that make people feel like, oh, wait, why are you asking me that? Because we're just trying to ascertain as much information as we can to learn really about what's going on and to try and identify possible opportunities to come to some sort of a resolution. So our goal, you know, all of us have biases, but our goal is to stay as neutral as we can in terms of how we hear and share information, and not to make any judgments about it, and just to gather it in order to advance the process. Hopefully that answers your question, Ron.
Yeah. Tori says she does not envy your job.
Thanks, Tori. It's not, yeah, there are days where it's really, really hard, and frustrating. It's frustrating because there's not, you know, right now with COVID, I mean, Heiner knows this, those on the call who are at all involved, Tim knows this, Ron knows this, in the RHRC and the coalition, you know, this is about largely right now about funding. And so that is such a big obstacle for a lot of people. So many, and all of these rental pieces have to be COVID related income. And then there are also people that have needs that aren't COVID related. And right now those are kind of really just really, really tough to deal with.
Do you ask both parties to make concessions?
We encourage both parties to make concessions. We you know, the one of the things that I think Amy and I would say is the hardest thing to hear from either party. It doesn't matter if it's the landlord or the tenant. When we hear the, you know, this is a matter of principle, I just want to basically hang up the phone and go upstairs and get a cup of coffee, because at that point, what I hear as a listener is, I've taken a position and I'm not willing to move off that position, and that's really difficult. You know, so our job is to try and understand what are the underlying interests, right? Is your interest in keeping this tenant in place? And if it's not, how do we accomplish, you know, if the landlord says, I just really want to get to a workout of a move out, how do we do that in a way that's best for everybody? And same thing with the tenant. So it's really important for us to try and understand what are the key interests that have to be satisfied. And then sometimes there's going to have to be some concessions made by both people, right? A tenant might want more time. A landlord might want more money. We can't all get everything out of this situation. We wouldn't be in mediation if there was a perfect solution.
Do you talk about the impact of the situation on both parties?
Oh, sure. We try to. I mean, Amy, I'm doing all the talking. Do you want to have a shot?
Sure. I mean, I think a common example is often when we get a tenant calling us, sometimes they call us and say, I want to, you know, file a complaint against my landlord. And then they talk about conditions in the property and repairs they need done. And then after a few, you know, more moments, a few more questions, I get to the, well, have you been given a 5-day notice? And yes, that's really what's prompted the call. And I have that conversation about the fact that, you know, if they're holding on to their rent because they want repairs done, that that may seem in their mind the fair thing to do, but then we have a conversation about, you know, the laws around that, and the fact that they very fairly can get, not fairly, but under the law can get evicted for holding on to that rent. And if a landlord would have that conversation with the tenant, it probably wouldn't be heard and accepted in the same way as it oftentimes is when you have that conversation from the mediator standpoint. So we do try to have tough conversations about the reality of the circumstances and the potential negative outcomes if tenants take a certain path, and really work to try to identify benefits in considering other options. And on the flip side, we may have that conversation with the landlord. And again, to the neutrality piece, we're not judging the situation or judging the individual. We really are just trying to add maybe a different perspective that could help move parties to the place where they're thinking, okay, I can live with this type of outcome. It maybe isn't everything that I was looking for, but it's certainly better than other alternatives.
So kind of speaking to that, Amy, I mean, what do you do when you have a tenant that's basically in a hopeless situation as far as staying? How do you deal with that situation?
Hopeless from the standpoint of it's not an option to stay.
Well, they'll never get current. They're not eligible for money from any resources that are available today due to COVID-19.
Right. I mean, it's really going to depend on the case. If that's one where we can help them get to a place where they recognize they need to move, we're certainly going to have that conversation and help them explore options for making that happen. Unfortunately, if they don't feel that they have options for making that happen, we can't make it happen for them, and we can't convince them to move out if they don't have those resources. So, I mean, certainly there are some limitations to what can be accomplished through mediation if the willingness isn't there on the part of the parties or the means.
Yeah, we also try and identify other sources, organizations like 211 that might have resources, or Hope House that might have also some forward-going ability to help, or this is where we try and just identify any possible thing that might help. And we talk to people about, even when they say, I don't have any place to go, we also talk about trying to figure out what else to do, because adding an eviction on top of it is only going to exacerbate an already very dire situation. And at the end of the day, sometimes there are days where Amy and I will call each other at the end of the day and we both just want to cry. And then, that's just the reality.
I mean, and piggybacking on that, Joanne, I know Community Advocates does an awful lot of work, and there are donations from organizations for people like that that don't qualify for the government money, if you will. So again, Community Advocates will do a lot of legwork on that to help that person.
Mm-hmm.
Yep.
Yeah.
I'm going to ask Amy and Joanne, if you don't mind, if Evan wants to comment on something or add something, since I know he's deeply involved in this. I'm going to unmute you, Evan. So if you want to say something. Hey, Evan.
Hey, how you guys doing?
Good.
Yeah, I mean, I have nothing to add to the mediation commentary other than, it can be very productive, as they said. A lot of times landlords and tenants have reached a point where they can't communicate with each other and they don't trust each other. And the trust aspect is a very important one, because if you don't trust the person you're trying to work out a deal with, then the odds of you being able to do that are next to nothing. So sometimes it does help to have a third party come in, a neutral third party come in and try and see if they can find common ground. So I definitely think it can be useful at times. It just depends on the situation, but it's another resource that landlords certainly should look to.
And we do, and Evan can speak to this, we will also mediate where the landlord's agent or representative, in this case maybe an attorney, where we're dealing with the lawyer and not the landlord. So, I've had cases where it's Evan and I talking through it and then me talking to the tenant. So it's also possible to work with whoever might be your representative if it's not you.
And that's right. I was able to work with Joanne on a recent case, and we were able to get Joanne was able to get the tenant qualified for some funds, actually a substantial amount of money. And we were able to work out a stipulation in that case where the tenant both made a payment, a substantial payment towards their back rent, which left the tenant with pretty much a zero balance. And we were able to negotiate the tenant to move out, to have some more time to move out, but to actually vacate the unit. So that was actually very helpful.
And piggybacking on that, Evan, it's been communicated to me through community advocates, and I think perhaps Amy and Joanne can verify this. They aren't about giving the tenant money so the tenant can run off and spend it somewhere else and screw their present landlord. They're very much about taking care of the present landlord and moving the tenant to another location if they cannot afford to stay there that's less expensive. And so I believe them when they tell me that that's a priority to them.
Well, it depends on the situation. There's in my circumstance, the tenant wanted to stay and had made that clear to Joanne that she would prefer to have stayed. But at that point, they had reached an impasse with the landlord, and the landlord was not going to consider that. And so what we figured out was an option where the tenant would buy themselves some time to get a new place lined up to move. And what we did was called a pay and move. And sometimes a pay and move is the best situation because the tenant doesn't have to move out immediately. They have some time to find a new place and to, move out at a fixed date. In this case, it was September 30th, but the landlord gets some money right away in exchange. And frequently that's not the full amount that's due. Sometimes you'll say, hey, I'll take, $2,000 or $1,000 and in exchange for giving them till the end of the month, but it gives some certainty to both parties.
And the other thing that we know, and Evan and I know that's on this particular case, that kind of a process where it's like, okay, initially community advocates was only providing funding to have people stay. And we spoke about the need to be a little more flexible because staying isn't always the best solution for anybody, landlord or tenant. And in our situation with the case that Evan and I worked on together, I think the tenant and the landlord were both happy with the outcome and they were working well with us. And so the temperature was very much brought down. And I think that property was left in good condition. And so some of those concerns that can happen with, a more escalated conflict start to go away because, there's an incentive to just get things to be in a little bit better space.
And there is a caveat I do need to put in here. With the CDC moratorium, it's unclear whether a landlord could default a tenant on a stipulation such as that. So we can enter into these agreements and we can file them with the court and the case will get dismissed pursuant to the stipulation. But if the tenant violates the agreement by not making a payment, then it's not clear at this present moment that we would be able to default the tenant without violating the CDC moratorium. In the case that Joanne and I worked on, the party that was paying the money was a third party. It was community advocates paying, the RAP funds. So the odds that the payment was not going to go through was next to nothing. But as far as the move out date, I don't know what I would have done or would do in a case right now as the attorney on a CDC, during the CDC order, if the eviction was based on non-payment and the tenant defaulted on the stip. There has not been a ruling. I actually asked the judge today when I was in a Zoom hearing with her whether she's made a ruling on the enforceability of stips during the COVID moratorium, and she hasn't made a ruling on that. So we don't know the answer to that question at the moment.
And I hope, Evan, if there's at any point that there's information, you'll update all of us because that's critically important for us to share.
Absolutely.
You're on mute, Ron.
Yeah, okay, I'll unmute myself. Joanne, Amy, do you have anything else to add?
No, just that if if you think of a question that you didn't get to ask now, it comes up later. Our email information is there. We'd be happy to answer questions later. Oh, Heiner has another comment.
All right, I'll unmute him as soon as I find where he's hiding. There he is. Go ahead, Heiner.
Oh, he's still muted.
Heiner, you have to unmute yourself.
Oh, there we
you
go.
are.
There we go. Now I got myself. Yeah, I wanted to comment on my haircut, which I got for the first time since February.
Nice. Looks great, Heiner.
Thank you. Thank you. I just wanted to alert the landlord crowd out there, and also you, Amy and Joanne. Appreciate all the good work you're doing. In my viewpoint, legal action has taken an unfortunate, I think, attitude in some recent filings where they're saying that basically with the CDC order that if there's a tenant who files one of those, there's just no way to challenge it. If you're a landlord, you've got to accept it, bite the bullet. They're there for 4 months or 3 more months of free rent through December, which I think is unfortunate that happened. Who knows how the courts are going to do that. But I think the important thing about that is to consider that if landlords and tenants work together, with your help, they can stay in the unit, pay some partial rent. And when January comes around, the landlord is not going to be all gung-ho to evict this person who has, shafted them out of 4 months worth of rent. So I'm not quite clear why I suppose from a legal standpoint, legal action is taking this attitude that you just are not able to in any way challenge the tenant's declaration that I can't pay rent, I don't want to pay rent. We'll see where that goes. It's going to come up in front of Judge Connolly, I think, and it'll be decided at some point. But my comment was actually prompted somewhat by, let me see here. Godan, he had commented that, well, I'm just going to take my units off the market for now. If I can't get my rent, I can't afford to support someone who's not paying rent. It's unfortunate. People need housing, and it's a shame if landlords are going to get the impression that, geez, if I rent to somebody, the next month they'll not be able to pay me. So hopefully this stuff will work out. We've got a good cooperative relationship with Mediate Milwaukee and with the Rental Housing Resource Center, and hopefully we'll work along on this. That's all.
Somebody asked if your PowerPoint would be at our website. Yes, this will all be recorded and it will be on our website. So one more
Wait, there's
time.
one more question. Hang on a second, Ron. There's what if a tenant hasn't paid rent? They were approved for RAP and it was paid to the landlord, but now October. Oh, this is a point we wanted to raise. So thank you very much, whoever asked it, P. Luce, for asking this. A couple of things. There is a cap. There's a maximum amount that people are eligible for through any of these programs. And if someone has applied, so when we've been in a couple of things that we've seen happen in cases that we've been mediating, where we've submitted applications for rental assistance, and depending on the timing, right? So maybe it was early September when the mediation started, and by the time everything got done, it was approaching end of September. I've asked the funding agent to amend the amount and to go back to the landlord and ask them to include the next month. So that was one thing. And then I had another case recently where the case was, we resolved, we had a mediated agreement. It was one of Tim's property tenants, and the tenant wasn't doing what they were supposed to do for this month's rent. And I looked at the amount that they had received through COVID, and they were still impacted by this loss of job. And I had them go back again. We contacted the person at Community Advocates who had helped with the initial funding and asked if there was any ability to give this person some additional funds because they were still below that threshold, Affordable Rentals got an updated application and they approved them for September and October rent. So there is, depending on what they've been qualified for already, sometimes the ability to get additional funds.
Actually, Joanne, I want to jump on that. One good thing is, as we talked about earlier this afternoon, Community Advocates still has a fair amount of money available. So at this point in time, they have half of the funds, approximately half the funds available that they were given initially, and we're hoping that they will get additional funds. But Joanne, it's also my understanding, because we had this conversation when Community Advocates was on, if I apply at one location and I get $3,000, I'm the tenant, and then I'm still unemployed 3 months later, I can reapply at, I'm not sure if you have to go to switch locations, but it's not fraudulent, and you can reapply for additional funds, which is kind of what you're saying.
Yeah, Amy, you want to go ahead?
I just, from that same presentation, Ron, that was my understanding, that they're saying you could apply to a different agency to access those funds as long as the months that those funds were paying for don't overlap. And so right now, it's my understanding that Community Advocates can spend up to $5,000 on the same individual.
Yeah.
Which is,
So the bad news is it's taken quite a while to disperse the money. The good news is there's still quite a bit of money available.
mm-hmm.
Well, and what we're seeing is I think the biggest issue is that there just is not a sufficient level of awareness at the tenant level about what the resources are. And some of this is, and we didn't talk about this in our presentation, but Amy and I both know from dealing with this a lot. Some of the folks that are, you know, we're encountering people that we've never encountered before, who've never had difficulty paying their rent. I mean, I've talked to people that this is the first time they've ever lost a job. They've been employed their whole life and they got laid off in February because, you know, that somebody was a driver for a limousine service. Well, there's no airport travel anymore. So I mean, that was just gone. And, you know, unemployment didn't come in. There's just lots of people, and they didn't know what the resources are, and you're just not functioning with your best executive thinking because you're under terrible stress. And so to the extent landlords know what these resources are, can help their tenants access to them, it's good. It's good for everybody. It's good for you. It's good for your tenants. So we certainly want you to be able to know what those things are to try and help this go.
Yeah, Evan has weighed in on this, saying that if I understand what he's saying, if they've been through the cycle once and they want to be able to access the funds, you as the landlord have to issue them a 5 or a 14 day.
I don't think that's true for Community Advocates.
No,
I think it's maybe
Okay.
true for SDC, but I mean, I know I worked with a tenant and the landlord and got the tenant's rent paid through August. I touched base with her, you know, earlier in the month in September to see how things were going, and she said that her unemployment was still in adjudication, or I forget what the term was. So I said, "Do you need help for September?" She said yes. I went back to Community Advocates. She didn't even have to apply again. They used her prior application, just got more paperwork from the landlord. And actually today they said they're paying through October. And to my knowledge, there was no 5-day involved at all.
Okay.
But I
Now,
think it could be different for SDC.
Right. Maybe, and certainly if they're trying to access emergency funding, which is a different bucket of money. So if you have someone who isn't COVID eligible, wants to get emergency funds, emergency assistance, that requires a 5-day, always has, still does.
Okay. Yeah, that would be, yeah. Well, once again, Amy, Joanne, thank you very much. Hopefully, I know you're quite busy right now, but a great resource for landlords to help their tenants. And if you can help your tenants, I mean, I'm not sure what Tim's phrase is, but we're both this one side of the coin and we're hitched at the hip. And if one succeeds, the other succeeds. If one fails, the other fails. So you got to work together on this. And
Hey, Ron,
Yes,
Evan is asking if he can weigh in orally for 1 second.
sure. I gotta find where he went to.
He's next to Tim.
Well, that's for you, I think.
Oh, for
just-
me.
Gotcha, Evan. Hang on here.
Thank
Yep,
you.
Evan, go
Can you
ahead.
hear me?
Yes.
Sorry, my fingers were getting tired there. You guys should all take a look at the CDC order. It's not actually that long. It's pretty short, and most of the important stuff happens in a couple pages. But the debate over whether you can issue a 5 or 14-day notice comes down to 1 or 2 sentences in the CDC order, and the CDC order prohibits a landlord from evicting once a tenant has provided the CDC declaration. But the way that they define eviction is, I think, where a lot of the dispute is happening between legal aid and legal action, who are interpreting it more broadly, and landlords and landlord attorneys who are interpreting it more narrowly. And the definition, I'm just going to read it because it's only 1 sentence, but it says evict and eviction means any action by a landlord, an owner of a residential property, or any other person with a legal right to pursue eviction or a possessory action to remove or cause the removal of a covered person from a residential property. So the way I look at that is that it says, or other person with a legal right to pursue eviction. Well, you don't have a legal right to pursue eviction until you've served a 5-day notice or a 14-day notice, and that notice has expired. At that point, you would have the right to pursue an eviction. So that's why I believe that you are entitled as a landlord to continue serving 5 and 14-day notices. You're just not allowed to file an eviction case if the tenant has provided you with the CDC declaration. I can tell you that from what I've heard from legal aid and legal action, they're taking the position that even serving a 5 or 14-day notice on a tenant that provides the CDC declaration would constitute a violation of the order, because in their opinion, that would constitute any action by a landlord to remove the person. So it's a very fine distinction, and there's no judge that has ruled on it, and I doubt there will be a judge that's going to rule on it before the thing expires at the end of December. But there is definitely a dispute as to whether you can continue to serve 5 and 14-day notices. You can keep doing it as long as the tenant has not provided the declaration, but if they have provided the declaration, there is a dispute whether you can continue doing that.
Thanks for that.
Okay. I don't see any other questions here. So with that, Amy, Joanne, any last words?
No, just we appreciate being invited. We appreciate you working with us, Ron, for all this since the beginning.
Well, I know you've been very, very busy, and we appreciate you taking the time to meet with us.
Yeah, well,
And we're
Thanks
just
for
going to
the
make you more
opportunity.
busy.
Hopefully.
okay, thanks. Good luck, everybody.
All right.
Yes.
Good night,
Take
everybody.
care. Be safe.
Good night. Take care.